Good afternoon, everyone. My name is Manoj Jain, and I'll be taking the session today on GDPR, and it's a very relevant topic today, and we'll be covering fines and penalties. So while we are waiting for information to load, I'll just share my screen, and we'll wait for a couple of minutes for the audience to join in, and then we'll get started. So just some logistics information here. I mean, you can read through while we're waiting for people to come in. But if you have any problems joining the session, you can try to refresh in terms of you can't see or you can't hear. You can try to reconnect, and then it should work. Otherwise, you can drop a message, and we'll check our side if there's any problems. Okay, I guess we can get started so that we have it wrapped up at the right time. Just give me a second. So this is a session that we are covering, and the focus today will be on penalties that have happened more recently on GDPR, and we'll try to cover maybe the instances that have happened as well as the nature of the penalties and why it took place, the amounts involved, and also just to ensure that the different audiences that we have are also catching up on some of the important things. We will give a very brief overview about what the GDPR requirements are. Some of you may or may not have attended the previous sessions that we have had, and we are planning to have another 3-4 sessions on GDPR. So let's kind of get started. This is my name is Manoj, and I'm the co-founder director of Wipro India. This is a brief background about myself and the experiences. So majorly focusing on risk management, regulatory compliance, having worked overseas as well as in India with banks. And Riskpro was started in 2011, and since then I've been associated with Riskpro as a founder director. So again, as I mentioned, we need to understand this overview because all the penalties are going to focus on what went wrong and why. So a quick background about the different principles that we have under GDPR. And also maybe, I'll quickly take it up because we don't want to spend a lot of time on this and really get down to the actual penalties and what happened and why. But essentially, the 6 principles that we have are lawful basis. The first one, which means that every data that we process under GDPR has to have a lawful basis, and it has to be done transparently, fairly, and it should not be unambiguous, and it should not be something that is illegal. The second principle talks about purpose limitation, and this means that data that is collected and processed can only be done for a specific and legitimate purpose. It can't be used for any other reasons or any other purposes that have not been stated to the data subject. The third principle talks about data minimization. That means you should be collecting only data that is relevant to your business and nothing excessive, and it should be relevant as well as it should be limited. So you cannot collect extra fields if you have no requirement for those fields. You cannot collect extra information if it's not required. The fourth one is simpler accuracy, which focuses or talks about that data should be maintained accurate and kept up to date in any business that is taking and processing the information. Fifth one is storage limitation. This focuses on data retention and data deletion policies, and it says that companies should store data only as necessary, or as long as is necessary and required for that activity. So if you are doing a particular activity and you only need the data for a defined activity period, you would save it only for that duration and then have to discard or anonymize that information. Sixth one focuses on information security related controls, and it says that uh, all the controls that are implemented should be sufficient to ensure data protection of that information that is being processed under GDPR. So all your information security, ISO 27000, encryption, BCPDR, all those controls would be part of Principle 6, and it would meet that requirement. The next slide here is actually focusing or stressing upon the first principle. So first principle says process lawfully and fairly. So this slide breaks up that what is lawful and what is fair and transparent. It has six elements to it. There is consent, there is contractual necessity, legal obligations, vital interest, public interest, and legitimate interest. So each one of these could be in a specific situation. We'll have to use one or more of those lawful bases in order to carry out processing. And if you don't have any lawful basis, then you're not allowed to process the GDPR information or the personal data that we have collected. Uh, so very quickly, like, as an example, if you are doing email campaign, email marketing, and if you don't have consent, and if you don't have any other lawful basis, any of the six lawful basis, then you're not allowed to send those emails out. But if you have consent, somebody has given you consent and says, yeah, I'm okay to receive marketing mails, then you can use that consent as a lawful basis. Or if you have a legal obligation, that the law requires or the regulators require to send certain mails out. Maybe things like, as an example, we have Aadhaar verification. So Aadhaar as a regulatory or a government program, it requires an email or notification to go out to each user whenever there is authentication happening on the Aadhaar database for that user. Since it's mandatory, the banks and the organizations, the NBFCs, don't need to take consent or any other lawful basis. It is directly given by the legal authorities, and that's when we can use those or send out that message that this is authentication that is happening. uh, and related to that, I mean, the authentication message can come out from the Aadhaar database, it can come out from the organization, but the situation is that if there's a legal requirement, then the information is processed accordingly. uh, it's very important that these two slides kind of become the core and the overall, the heart of the GDPR principle, because most of the fines and penalties would essentially revolve around any of one or more of these non-compliances. And that's because this slide pretty much summarizes everything that is going to happen in the company. And then this slide breaks down with further requirements, and a lot of problems are going to happen in these six principles. The subsequent regulation and the articles don't really have a lot of issues or problems, but more so on these specific six slides, because six principles, and this is something that is very difficult to understand, and that's where the problems come. uh, Looking into the fines and penalties, so these are essentially categorized into two buckets, and these are the maximum fines. The minimum fine can be a lot less. It could be thousand, dollars, or £1,000, €1,000. It can be 10,000. It can be 100,000. It can be nothing, or it can be higher of these. So essentially, the penalty limits are 2% or more of your global turnover as one bucket, and 4% or more. So it's not a cap. It's actually, in a way, a minimum maximum limit, which means that the fines can go as high as 4% or 2% of your turnover, or more than that. Uh, and the buckets essentially focus on certain elements which are less severe in terms of non-compliance, and certain which are more. So it's important to see what these elements are. Looking into the left hand side on the 2%, we see that child consent is a requirement under GDPR, which says that if you're processing information for people less than 13 years of age, you need parental consent, and if you don't have that, then that's a 10 million penalty or more. And the next one says data protection by default or by design. So these are elements in under GDPR that says that anything you do, whether it's a process or any application, software or a website, it has to ensure protection by default or data privacy by default or by design. I'll quickly take an example here, like how we have had on LinkedIn. So I'm sure many of us connect on LinkedIn and browse through profiles and everything. In the past, you could download all your contacts in an Excel file. So all your connections and their emails will come in an Excel, and you can download the information. Because GDPR came in and subsequent to that, you can still download the information, but now the emails are blanked out. So the email column will be blank unless the person or that individual whom you're connected to has actually enabled that functionality in his profile, and he says that okay, allow my email to be seen by people who download these contacts. So this is nothing but privacy by design, which means you design your applications and your architecture in such a way that you turn the functionality off, and you allow a user to turn it on and expose or increase his exposure on personal data sharing and data use. So these concepts, if you don't follow, and if the regulators of the view that okay, you're not followed the fundamental concepts of protecting data, masking the data, and hiding it from people, then it will be a 10 million fine. Processing excessive information, that's a data minimization element, that is 10. And if you are required to have a DPU and you don't have that, then that's a 10. What's on the 20 is a more severe, and those are all the six principles. Basic principle of processing, that is six principles, 20 million or more. Conditions for consent, which means if you want to take consent as a, and if you want to take consent as a lawful basis, and you don't have the conditions to meet that, you have not taken unbundled consent, you have not taken explicit consent. There are many elements and parameters to consent, and if you don't follow those, they are all 20. Data subject rights means that individuals can approach you and say, delete my data, give me my data, edit my data. If you don't follow those, that's 20. And then cross-border transfers of the data and non-compliance with any supervisory authority order. So those are all 20. So we see here that the 20 million or more are essentially more conceptual and more high-level principles. If you have non-compliance to those, then that is a breach. Okay, so moving on, and let me just see. There's a okay. So someone seems to have an issue with the video. I'm not sure. He's saying that the slides are not moving, but I'm sure maybe it'll catch up or it should be fine. Okay, so in case it's not there, just let me know. I'm not sure because my view is showing as okay. People can see, so I think it should be okay. Right. Just give me a second. Let me just check. Make sure it's. I have turned it off and on again in case someone has an issue. So just let me know if it doesn't come through. Yeah. So we were covering this slide, and I'm just displaying it in case somebody missed this out. Just to kind of summarize the points, and you can visually see what I have been talking about. So these are the 10 and 20 million, and moving on to the next one. This essentially is a graphical representation of the kind of breaches and problems we are having today. So here we see what are the odds that you're going to get struck by lightning is 1 in 960,000 chances. Again, another example, dating a millionaire 1 in 220, and experiencing a data breach. This is 1 in 4. Uh, we today we see a lot of breaches happening, and 1 in 4. I don't know if it's an exaggeration or it's a real study, but the source is IBM, and they've carried out a study. So breaches are very common, and all the breaches are covered by GDPR as a specific requirement that in case a breach happens, people have to be notified and action has to be taken. So the odds are increasing quite significantly, and that's why the regulation is more important to us. And let's try to understand what the regulation really is, and what are the requirements of each element of the regulation to the extent that they apply to fines and breaches. So here we have a definition of personal data breach, and which means that breach of security leading to accidental or unlawful destruction, loss, alteration, unauthorized disclosure, or access to personal data, transmitted, stored, or otherwise. So it's a very long definition, but in a nutshell, what it means is data has been compromised. It has been shared with the people who shouldn't be having access to the information. It has been destroyed. That means it's not available, and it has been altered. That means someone has modified the information. So don't think of a breach to only mean that someone has hacked into the system. It can also mean that someone went in and modified a telephone number which is unauthorized. It can also mean that some website that is required to be available is not available for people to use and see. So even availability is covered as a breach, even modification of data is covered as a breach, and of course the unauthorized access. And there are very many examples of different types of breaches, and we have been studying the sanctions and the fines of various regulators. Some examples that I would share would be like when you're sending out a mail to somebody, and you're attaching an Excel file to that. Assuming you want to send to 20 people, and by mistake you put the 20 people in a CC instead of a BCC, or it goes to the wrong recipient. Now, the regulators will take a view. Yes, okay, it was a mistake, but depending upon the circumstances, the data shared unauthorized or disclosed unauthorized, they may actually carry out that fine and that penalty. So they would not go by the view that it's a mistake. Okay, I forgot to put the right recipient. I selected the name, but it went to the wrong specific person. So that is no excuse. Essentially, the requirement is that unauthorized disclosure should not happen. So that is an example. There was a fine, I think about 6 to 8 months ago. uh, a certain group was created. I think it was relating to child abuse, and there were about 70, 80 people who were part of that organization about child abuse or something relating to that. Uh, and an email newsletter was to go out to those 53, 55 people. By mistake, instead of putting the BCC, the person had sent out the newsletter in the CC. So although every one of those 53 people was part of that forum, no one knew that this person was part of the forum. So it's like everyone knew that I am part of the organization about child abuse, but I didn't know the other 52 are also there. So that is called unauthorized disclosure of the information that somebody else is part of that. And of course, his email was seen. And there was a very heavy fine on that specific case. So these are different examples, and we'll try to see, some of them which you are already aware of, some of them you may be aware of, as we discuss now. Uh, so the first one, which is not really a GDPR specific, but nonetheless, let's cover it just to understand what data breaches look like. The Aadhaar breach, 1.1 billion Indian citizens' data was exposed. Aadhaar numbers, names, emails, all the information was kind of exposed. Starwood, which is a Marriott-owned hotel, it exposed 500 million Starwood guest personal data, account information, travel information, credit information, because the servers had suffered unauthorized access. So this is basically hacking and unauthorized access to the databases about the Starwood, I think the preferred guest program or something. Uh, Exactis, it's a data collection firm. Personal details and physical addresses of 340 million consumers, their users' data and businesses' data across the internet was exposed because of data relocated to a public site. Uh, Facebook, we keep hearing about Facebook, WhatsApp, Instagram, and all this. So these are again examples of various elements within the Facebook website that have a bug or that have a lapse or a security loophole, due to which data is being compromised and stolen. It could be token stealing, it could be third party related, or it could be the fact that the functionality of that application is not privacy by design and all, and people have misused that. Quora is 100 million Quora users. Information was available because a third party had gained unauthorized access to one of their systems. So in most of these breach categories, we see hacking. We don't see availability aspect. We don't see that someone had wrongly modified, altered. So typically what we see as breach is actually data stolen. And these are another set of examples which also talk about the same thing. MyHeritage, Elasticsearch, Newegg, Panera. All these are examples of exposure of client data. And because their websites were hacked, or they had vulnerabilities in the application code, and it could be several of those reasons. So, how do we really tackle such breaches? And some of the ways in which we could do that is by putting in place a data breach response plan. So, while a breach response plan doesn't really address preventing breaches, it at least ensures that the mitigation happens very quickly. Which means you need to identify a breach has happened. You need to identify and review your monitoring logs, your audit logs, server logs, application logs. You need to make sure that you are on top of when an incident happens, you are aware of it and you react to it. A regulator will take a positive view if you identified it fairly quickly and you contain the damage, and you're able to resolve the issue. And they will be actually not so supportive if the fine, or sorry, if the breach has been going on for the last 2-3 years and you have not done nothing about that. Second aspect would be you need to make sure that you're reviewing contracts with your third parties, because several of these breaches essentially are going to involve third parties and compromising data at third parties. And finally, you have to make sure your systems are in place. Your information security systems are foolproof. Your networks, your firewalls are strong. Your antivirus, malware programs, or anti-malware are all working. Here, there's a study that was carried out by DLA Piper Survey. So I thought this was interesting. It essentially focused on or did a survey on breach complaints over the last 8-9 months of GDPR. And this is the outcome of that information. We see here the number of data breaches that have been notified to the regulator. So companies in Netherlands will notify the Netherlands, the Dutch, regulator. And then German regulators will be notified by German authorities. Similarly, all the different countries. So we see here a large number of breaches that have been notified to them: 15,000, 12,000, 10,000. And although Netherlands is an extremely small company, the only reason that it can explain, or the survey says the explanation for 15,000 reports, is that they were already having since 2016 this program that any breach happens, notify me, which means that that's what the regulator says. So the culture of reporting was already in place, and it's been 3 years or 2 years since companies have been reporting, which is a positive thing. Now, GDPR has come in more recently, so all the other countries are catching up, and the culture will only increase as the number of companies already into millions. These numbers would go up, which means every time something goes wrong, companies are going to report, because reporting is a mandatory requirement, and if you don't report, then there are penalties and sanctions. And when you do report, possibly regulator can help you and support you in terms of mitigation plans for that. So looking into information security control, because data breach is all about mostly about lapses in your information security control. Article 32 says that what you really need to ensure information security controls are in place. So it just has one sentence which is at the top of the slide, which says, taking into account the state of the art and blah blah whatever else it is there, the controller and the processor shall implement appropriate technical organizational measures to ensure a level of security appropriate to the risk, including the following: encryption, pseudonymization, ensuring confidentiality of the data, restoring the availability of the data in case there's an incident or the system crashes, and regularly testing, assessing, evaluating the effectiveness of technical measures. So there are two elements in this. One of the elements is that you should have sufficient controls in place depending upon the risk profile of your organization. So if you're a company of 10 employees and you process data, there will be certain level of risk to that data. If you're a 1,000 employee company, there'll be a certain level of risk to that data. Another scenario can be you are a 10 employee company, but you are processing email marketing for a client, and your email marketing list is say 100,000, 500,000 records or emails, versus a 10 employee company who's just doing maybe payroll for 50 employees, payroll processing for 50 employees of that client. So the risk profile determines what controls you need in order to mitigate and comply with GDPR regulation. So it's a risk-based compliance, and we get a lot of questions saying that, okay, what are the information security measures necessary to prevent a breach or a compliance? Well, we say that whatever it takes to ensure that there's a risk-based mitigation plan in place, whatever is required to ensure that the data is not compromised and you comply with the regulation. So you may not need encryption for a 50 record if you think that that is what it is. It's unnecessary and burdening the companies for that. Anyway, the bottom line message is that GDPR does not define or prescribe a limit of security, a list of security controls. It just says that do what is necessary to meet these four objectives, which is availability, integrity of the data, confidentiality. Make sure you test the procedures out. So you're testing, you're monitoring system reviews, access reviews, internal audits. They become very important because that is one of the four elements of the requirement. You have everything, but you better also test it and make sure they're working. So that is your periodic reviews, reconciliations, annual reviews, and things like that. So monitoring controls assumes a lot more importance here. So we see here GDPR penalties are not just because of data breaches. GDPR penalties can also be due to transparency. You're not transparent with your users. Inappropriate consent, you have taken consent in the wrong way, privacy by design violations, non-compliance with data subject rights, cross-border transfers without appropriate measures. So all these examples, are what GDPR is all about. So data breach is one of the 10 things, one of the 50 things that can go wrong in GDPR, and everything else is also there which can go wrong, and they also have equally heavy penalties, like any of the principal breaches, data retention breaches, data use breaches. What is the purpose of use? What is the purpose of consent we took? Mismatch of those. So there are many more things that can go wrong. It's just that those things have not started to come to light as much as it should have. I'm sure companies are doing wrong things, but for some reason, people are not reporting, complaints are not getting filed. As a result, what we see in the database of notifications are just breaches and not really the other elements of GDPR non-compliances. But they are there, and we'll see some of those here in the next several slides. So this is an example of a fine to TalkTalk data breach of customer details, which was found online. So in London, there's a TV broadcast mobile phone provider. It was known as TalkTalk. It suffered a breach. It resulted in the exposure of personal data and financial information of 157,000 customers, and it failed to implement the most basic cybersecurity measures that prevented hackers to penetrate. So it lacked the basic information security measures in terms of preventing the networks, ensuring that the code is safe, there are no vulnerabilities. So something that can be done very quickly, easily, and most companies of this size should be doing, it failed to do all of those. As a reflection of the seriousness of the event and the fact that fundamental controls of information security were not in place, the fine was imposed, which is £400,000. And then, this is essentially there are two elements to the fine. So we look at that. The bottom, you can see there are two boxes. So the first fine in 2016 was for that breach. That means people can see the data. The next fine happened again in 2017 for 100,000, and this was when data was shared with a third party, Wipro, and a couple of the employees of Wipro misused the data, and they started calling those customers in an unauthorized manner, which means the TalkTalk and Wipro contract said that once you get this database, you're supposed to do activity A, B, C. But the Wipro employees were carrying out activity D, E, F to the database for the maybe personal benefits or unauthorized access. Anyway, it's the select employees of that organization, Wipro, who were doing that. So that was another fine that was imposed at 100,000 in terms of misuse of the data and data sharing without proper consents and authorizations. The next fine was again at not really a fine, but more like a breach. In September 2018, British Airways admitted to a mega breach that hit 185,000 customers. This was essentially due to malicious criminal attack, malicious code that was injected into the system. Personal financial data were compromised. However, no passport information, travel details were lost. So this one is still under investigation. I believe there is no real outcome of this, more or less. But this was a breach that happened, and the data was exposed in this situation. Another one that was recently in terms of data leak was Ticketmaster. Ticketmaster essentially had a widget on their website, and that widget allowed maybe buying tickets for events and for games and things like that. A hacking group known as Megacard placed a skimmer code on a third-party software that allowed the group to access payment information. For millions of customers that use the website to purchase tickets, they had their payment card information stolen. So this is nothing but a malicious code entering into widgets into parts of your website, and you should be aware of what comes in, or you should be regularly testing the codes as well as maybe looking at information that is not as per norms. So in this case, external parties got into the website and injected the skimmer codes, due to which data was stolen. I'm not going to talk so much on the Facebook data breach because it's already fairly publicly available, known. But the fines have been there, and then in this case, the Irish at the bottom, the Irish Data Protection Commission has opened a formal investigation for this, and this could result in fine up to 1.63. So this is still going on, and there are several others that have happened on Facebook in different countries and all. Again, multiple instances of compromise. This is the one that maybe we can spend a minute or two and just look at why things are right or wrong. So Google, the maximum fine, one of the maximum fines under GDPR today is this 50 million fine. This was imposed by French Data Protection Authority, CNIL. CNIL said that the fine was for breaking the GDPR rules around transparency and having a valid legal basis when processing people's data. Uh, by far the largest fine this is there, and it was the previous fine before this Google was 400,000 imposed on Portuguese hospital. We'll also look at that case study after this. So what happened in Google was there was no transparency in the privacy policy, and the purpose limitation was breached. And we'll see on the next slide what kind of really happened. So the fact was Google's privacy policy on the website was too generic and vague when telling users how it will use the information, and it was also vague in terms of a lot of missing information about how long the data will be stored. So regulation says, okay, you should tell people, okay, when I'm taking your name, your date of birth, your phone numbers, I'm going to use it for creating a Gmail account, creating this, providing these services. But Google was not fairly transparent and trying to use it for multiple purposes other than the services you were subscribed for. Now, of course, Google and such organizations are very large, and typically it can become complex in terms of properly disclosing exactly what we are going to do out of the 100 things that we can do with this. So we wouldn't know the exact case unless we read all those thousands of pages of investigation. But the outcome and the conclusions that have been in the public domain are that Google was not specific as to what we should be doing. And one of the articles says that you should be transparent. You should be clear about what you want to do with the data. Tell the users exactly that thing. The second part was Google never collected valid consent for processing the data. So the consent was not specific. It didn't say, okay, for item A, give me consent. For item B, give me consent. For item C, D, E, give me consent. Google was more or less taking bundle consent, saying that by creating an account with Google, we will use this for our services without disclosing what kind of services, what type of services, is there a granular element to the services. So when you're just generalizing what you want this for without giving specifics, then that is called ambiguous consent. And an example we may take is maybe some travel agency is collecting information and saying that we are going to be in touch. please give your consent, we want to be in touch with you. Now if someone gives that consent, it will not be a valid consent from the travel agency's perspective. I mean, we'll be in touch. What does that mean? Are we going to send you mails? Are we going to send you, what is the frequency of that communication? Are we going to send you mails about travel trips, about holidays, or are we going to send you about credit cards, mobile phones, in international countries, SIMs in international countries? What exactly are we going to be in touch? So that is called ambiguous consent, and Google was kind of caught in that bracket. Uh, so the catch-all consent is extremely dangerous. I agreed to Google's terms and services, tick box, and then not really worrying about what it is to do. Uh, Regulators are going to be very hard on this, and just the fact that only Google has been caught so far and not many more, it's only because the regulation is fairly new. Even the regulators are learning through the process. But if this continues and lots of large companies continue to take unambiguous consent, bundled consent, vague, non-transparent, you would see more and more of these fines come through. And then at the bottom, you see the different problems that have occurred at Google. So let's look at one or two examples. These are coming from ICO regulators' website. Again, with respect to relevance and limited purposes. These are not penalties as such, but I wanted to share some examples of what are limited to the purpose, because Google was fined for storage limitation as well as the purpose. It mixed the purposes. So a recruitment agency places workers in a variety of jobs. It sends applicants a general questionnaire, which also includes specific questions about health conditions that are only relevant to particular manual occupations. It would be irrelevant and excessive to obtain such information from an individual who was applying for an office job. So essentially, what this is about data minimization. What it means is that when you have an application form, and if you're in the business of hiring people, say for the mining industry, in the mining industry, you always want to ask, can you walk? Do you have any health problems? Can you breathe? Do you have a heart condition? It's okay to ask those questions and gather that personal information, because the nature of the job requires that. But that same application form cannot be given to a receptionist role, cannot be given to an office job role, because in that scenario, it's unnecessary disclosure that I'm having a heart problem or health problem or a breathing problem. It's not relevant to the job. So that is called excessive data collection, and the data minimization rule has been non-complied or has been violated. Another example, an employer holds details of the blood groups of all his employees. Some of them do hazardous work, and the information is needed in case of accident. For the rest of the workforce, though, such information is likely to be irrelevant and excessive. So regulators are of the view that just because someday somebody might need blood, it doesn't mean you should take the blood group information of all your employees, 1,000, 10,000, 100,000. So it depends case basis. It depends on a scenario or on a specific geography of the company or the location. Maybe you're in a specific location where it's very hazardous, things happen regularly, or there's a past event that you can relate to this data collection. If you don't have any of that history and data collection and incidents, then collecting this information would be excessive and you would violate that principle. Looking into this fine for Equifax, it was fined, again, this is the old Data Protection Act, not the GDPR, £500,000 for failing to protect the personal information of 15 million UK citizens. Again, a cyber attack, they stole the information, and that led to failures, and that's because of failures at the company led to the data being retained for longer than necessary and vulnerable to unauthorized access. The fine joins the one imposed on Facebook as the highest ever issued by the ICO. Essentially, this is a case of data breach, and that was a penalty. Because it was under the old one, it was only 500,000. Otherwise, it could have been as high as 20 million or 4% of that turnover. This is a case study kind of thing, and it's a fine and an example. So maybe we'll spend some more time on this specific slide. The reason I found this relevant was because this scenario is generally available in many companies. So here we see a Portuguese authority, imposed fine of 400,000 euro on a hospital for multiple violations of GDPR. So the hospital failed in data minimization rule. Too many people had too much access, and it failed because it didn't have adequate information security measures. So what exactly were these problems? So first of all, there was no document linking user profile and the system profile or the system access, which means there was no role-based access defined in the company. Anybody and anyone could have the highest level of access, and that is what GDPR looks for. Is that you should be sharing personal data, private data, to only people who have a need for that particular job. So a receptionist, as an example, shouldn't be seeing the data or the patients or the medical history of the people in the database unless she has a need to have that. She may have a need to access a doctor's data because she has to take appointments and set up appointments, but not for the patients unnecessarily. So, you have to identify which employee should get what level of access to what kind of database. That is an expectation in terms of data minimization regulation, saying that minimize the exposure of data to restricted people to the extent that they need it for that particular role. There was no document defining the rules for creating users in the hospital's information system. So user ID creation, there was no process for that. People were just getting added, without any defined audit trail that this is a new employee, please create access. There's no authorization of the access creation, and people were being created. 9 technical employees enjoyed the level of access reserved for all for the medical group, which resulted in indiscriminate possibility of such employees consulting the clinical process of all hospital users. So there were 9 technical employees who need not have access, but they had the highest level of access, which is typically reserved for the senior doctors or the medical groups. And these 9 people had access to all the hospital users. Again, a mismatch of role-based access or the requirement for such access. Existence of access credentials which allowed any doctor, regardless of his specialty, to access at the time of data, at any time, the data of the clients of hospital. This was considered as violating the principle of need to know and principle of minimization. So here it was that any doctor had access to any patient information. Again, the requirement expectation is that if you're a doctor in the cardiology department, then why would you want to access patient information who have not been admitted or not been consulted for cardiology, health related, heart related problems? You're accessing data of pregnancy, you're accessing data of other skin diseases, cancer, and those things. So it is saying that only if the doctor has to have a need to access other department data, it can be on an exception basis, but not as a general rule that give him access to the blanket approval for the whole database. There were 985 users associated with the profile doctor, but in the official hospital, there are only 296 doctors. So essentially, people or the doctors who came in, who left the organization, their access was not deleted. Useless profiles maintained, and which were no longer providing services, were in the system. Only 18 accounts were inactive, and the last one was deactivated in 2016. So essentially, this is all a problem of basic access control at the organization, the hospital. Your basic information security measures of user creation, user reviews, access reconciliations, deactivation, all those were failing. And on top of that, you were failing because your role-based access was not in line. So in certain companies, role-based access becomes the most fundamental control that you should have, especially when you are dealing with large data sets. And we can take examples of many of our current companies, fintech companies we have. We might have Paytm, we might have other e-commerce companies. These are all extremely large data sets, and these data sets you need to segment them very, very precisely so that only certain people have access to certain information. If there's a person handling merchant data, then he should only be seeing merchant data information. He should not be seeing the consumer information or the user information. If someone is into digital marketing, maybe he can see the information of the consumers, but not necessarily the merchants. So that is, what needs to be demonstrated in order to prevent such fines from taking place. Here we have an example again from another authority. This talks about 180,000 fine to a taxi company. Authorities found that Taxa had implemented a data retention policy, but it failed to follow it. Personal data relating to 9 million taxi rides was being preserved beyond the lawful 2 years retention policy. So what had happened was Taxa determined that, okay, all the historical rights I will save for 10 years, for 2 years, because maybe I need it for certain information, or the person might want a receipt or any other information like that. So it determined internally that I want to retain such data for 2 years. But in reality, what happened was Taxa did not erase or it erased the data of the name and address of each person, but it retained their phone numbers. So while the name and the address was retained for 2 years, the phone numbers were actually retained for I think about 5 years, 3 years longer than necessary. And the reason it kept it for 5 years or another 3 years is because the phone number was used as an account number. That means your login information was the phone number, and changing that phone number into something generic, anonymizing it, was creating a problem, or the system was not supporting that. So essentially, what you had, or your taxer's intention was that I don't want to keep the data, but because I cannot support the system, if I change that, the whole user and the user information will go, the whole database will be corrupted. I cannot delete and change that information because the system didn't allow. So taxa admitted that the phone number itself was not required. An anonymized number would have been okay. However, its computer systems were unable to convert the phone number into a new unique ID. So the regulator took the view that it's your problem if you had a bad system or a system that cannot support data deletion. Why did you use your phone number as an account number in the first place? And if you did that, you should have found a better system that can help you to delete that phone number, because even though if it's used as an account number, or anonymize that data. So that's the 180,000 penalty. The intent was not there, but the fact that the systems could not support is a violation of GDPR. And here the point that we should take from this fine is that your systems should be adequately supporting most of the principles. You cannot take excuse that, okay, because my system cannot find this person, I am not able to delete him, or because I'm not able to delete such large data sets, I need to do certain reconciliations, that's why I'll take 2 years to do it or 3 years to do it. That is not allowed. If you define your policy that I have no requirement after 2 years, then that should be it. You should not have anything after 2 years. Or you define a policy that is slightly able to accommodate, but it should not be so excessive. You cannot say I'll take 10 years to delete the data, because I need 3-4 years for the system, 1 or 2 years for receipting and all that. So this is a very good example of a regulator's view that, okay, it's your problem, my requirement was delete after retention is over, and you didn't do that. uh, Here we have an example of a US, under a US regulation, which is child consent related. The US FTC announced a 5 million fine for a video social networking app, Musical, now called TikTok. And then the problem here was, because the company failed to provide direct notice of its information practices to the parents. That means privacy disclosures were not there. It failed to obtain parental consent prior to collection, use, and disclosure. As per COPA, which is the Child Related Online Privacy Protection Act, every child's data processing should be supported by parental consent. So that was not there. It failed to delete personal data at the request of parents, and it retained data beyond necessary. So maybe the user was inactive, or the user account was deleted, but the data was still retained in the system. Now, although this is a US fine, this can very well be a penalty under GDPR, because GDPR also has a child consent below 13 years of age. So if you are having a website and your kids are signing up below 13 years, you require parental consent for that. So you can see big companies, good companies are failing because somewhere in that whole process, they forget these smaller points, that, okay, I need to tell the parents what I'm going to do. Point number one can be failed very easily. Or point number two is still easy, because if you're in the child business, you have to take consent, which is easy to remember. But three, four, and many of these situations, you may forget to act on that. There are many things you need to do on a specific transaction. This one I picked up specifically because it's not a large fine, but a small fine. So don't worry, many of the fines will not be in millions. They could be as small as 5,000, 10,000 pounds. If you support the investigations, if you support the authorities, they will be, supportive, and they will actually, take all that into account. But certainly, make sure that the controls are implemented, and they should be implemented fairly soon. So what happened in this case was, there was a German chat platform, and it was storing passwords in plain text. And there were about 800 emails, and the passwords, associated passwords, were compromised or hacked. This fine is not high because the company cooperated with authorities, and it realized the mistake, and it suddenly and then quickly changed and encrypted all the passwords. So the point here is, passwords should not be plain text. So really, the GDPR doesn't say that password should be encrypted, but it is a market practice and it is an expectation that fundamental information security measures controls should be in place. So today we can assume, because this regulator has fined this company, we can assume passwords should always be encrypted. So that is the message we take from all these orders and case studies. So this is a small fine and a specific element. Uh, just one kind of one slide on this information just says what are the numbers for the Ireland's DPCU. So they issued their first annual report. Some of the reported numbers look like these: that 2,800 complaints were received. 35% of the portions of the complaints related to access rights. 3,000 were the number of breaches that were reported to the authorities, with over 4,700 over the course of 2018. It represents 70% increase. So numbers are not large, but it's an annual report that has been issued by the authorities, and in the annual report they have disclosed all these statistics. And likewise, all the different regulators of European Union will be disclosing the data as more and more maturity comes in the process. So this is it in terms of different fines. I'll just quickly kind of wrap it up with 1 or 2 minutes about our services. So some of you may have attended previous sessions or may already know about RiskPro, but at a high level, we have done 40 plus GDPR engagements, and we continue to do many more of these. We help with consulting, we help with GDPR trainings, we provide DPO services or a retainership model. We do privacy impact assessments and things like that. And then at high level, and what is in high demand today is many small companies want us to help them with retaining their maintaining their compliances. So like a retainership, 2 to 3 days will come into the company every quarter and do trainings, do awareness, verify the documents, verify the incidents, investigate, be available on emails and phones and that kind of support. So it's an offline support. It's cost effective and highly effective because it keeps the company going in the right direction. So I'll kind of wind it up here. If there are any questions, we can actually take this and then continue to move forward. So I'll just wait for a minute or so. If there's any questions, we'll address them. If not, you can always send an email and we'll respond to them. Okay, I guess there's no specific questions that have come in. So thank you very much for your patient listening, and I hope this was helpful. This video and the material will be available to you. And if there's anything, do write to us. We'll be happy to help you out. Thank you very much. Bye-bye.